Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Demaray, and Michael is a highly respected estate litigation attorney in Silicon Valley. He received his JD degree from Hastings College of Law, University of California in 1973. His honors include the Order of the Coif. He is a certified specialist in probate, estate planning, and trust law. Among his many distinctions, he is a past president of the Silicon Valley Bar Association and a fellow of the American College of Trust and Estate Counsel. Mike is also the author of the Litigations Tool chapter of the California Trust and Probate Litigation book, published by the California Continuing Education for the Bar. And one of the things I enjoy is each year Mike participates in a panel where they give an update of what's happened for the last year for the Silicon Valley Bar Association in the estate area. Today, Mike and I are going to, the topic that he's giving me here is, but my spouse agreed. And so we're going to be talking about marital agreements. Related to this, I caution our viewers again, get independent legal counsel and remind you that Michael is a California attorney who principally works in lawsuits involving estates and trusts. I'm a California CPA, and the rules vary from state to state, so you definitely need to get your own legal counsel. Hopefully this will be the beginning of your own conversation. Mike, thanks for joining me today.
Michael, thank you, and again, thank you for letting me wear a short sleeve shirt today. It's hotter than hell out there.
Okay. So today is it's July 26th, and it is pretty warm here in San Jose. All right, Mike, is there a difference between a premarital and a postmarital agreement?
Yes, there is, Michael. A premarital agreement is an agreement that you enter into before you get married.
Uh-huh.
A postmarital agreement is one that you enter into after you get married. Now, premarital agreements and postmarital agreements in a variety of forms have been around for a long time. And there have been many, many cases about the enforceability of premarital agreements. Spouses sign an agreement and it's pretty much binding upon them. However, as time has gone on, the courts have been much more restrictive about enforcing a premarital agreement. If you are the spouse that wants one, it's incumbent upon you to be sure that your other spouse has a lawyer to consult with.
Yeah.
It's not necessarily absolutely essential, but it probably is. Also, a few years ago, they changed the law with respect to premarital agreements to make them even tougher to hold up than other kinds of agreements or contracts.
Mm-hmm.
In a regular contract, in terms of whether it's fair, you basically look at it as of the time it was entered into. Under a premarital agreement, if you get divorced 10, 15, 20 years later, the courts will look at it in terms of its fairness at that time and may be able to set it aside on the grounds that it is unconscionable. It's not just unfair, it's so bad that it's unconscionable. So premarital agreements are not as enforceable as they used to be. In fact, there are a number of professional negligence actions filed against lawyers that charged $5,000, $10,000 to do a premarital agreement, and guess what? It didn't work out. And so what happens is the losing spouse turns around and sues his lawyer who had advised him about doing the premarital agreement for damages. And there are a lot of those out there. Now, a postmarital agreement is even tougher to enforce than a premarital agreement, because a postmarital agreement comes into play between two people who are now married to each other and who owe what are called spousal fiduciary duties to each other. What does that mean? Well, the courts, and I think properly so, recognized some years ago that when two people get married, they assume a special duty to each other. They owe a duty to each other not to take advantage of the other. Now, you might laugh at that and say, well, heck, my wife takes advantage of me all the time. But the reality of it, I'm afraid, is much, much different. And I'm not just talking about physical abuse. I'm talking about financial abuse. Even in these modern day and age, men just seem to think that because they made most of the money, and still in this state that's the case, because even though we have equal rights laws, you know and I know that men still get the best jobs and they get paid more than women do. Because they made it, it's theirs. Mm-hmm. And they may have heard that California is a community property state. And but as far as they're concerned, they manage it, they determine what to do with it. And sometimes they, I don't like to use the word bully, but they intimidate their spouse into making certain agreements about what we're going to do with that money, who we're going to give it to, who we're going to loan it to. And especially with respect to community property. And remember what community property is, Mike. Separate property is what you own when you came into the marriage, or what you acquired after the marriage by a gift or inheritance. Pretty much everything else is community property. Mm-hmm. Your earned income, my earned income. It doesn't make any difference. It's all community. And under the community property laws, both spouses have the right to manage the community property. Mm-hmm. If one spouse does something with the money that the other spouse doesn't agree to, the other spouse can set it aside, both during marriage and after marriage. So these spousal fiduciary duties basically say that if you're going to into a postmarital agreement, you have to use the greatest integrity and the highest good faith possible. In fact, what the law says is that if you have a spousal fiduciary duty, which you do, you cannot enter into an agreement that is unfair. If you get a benefit from the agreement that is quantitatively better than the other spouse can set it aside. You might say, well, you know, we weren't just engaging in what's called pillow talk. We sat down at the table and we agreed that these houses that I bought through my job, they would all be my separate property. And she signed an agreement and I signed an agreement. And I wasn't forcing her, she was happy to do it. And you're telling me those agreements are not binding on her? And I say, that's right. Well, why aren't they? She promised, and I said, but you basically, because you were her fiduciary, mm-hmm. you got an advantage from that she didn't get. What did she get? Mm-hmm. Well, she had the right to continue to live with me. I wouldn't divorce her. And the courts say that's not good enough. Uh-huh. You can't take advantage of your spouse in a postmarital agreement. So you might think, well, if I'm not taking advantage of her, why do a postmarital agreement? And you'd be right. Maybe you shouldn't. Maybe you should get her consent before you do something. And that consent has got to be something that is fair to both of you. Does that mean I can't give money to my children for their birthday, my children by the prior marriage? No, you can do that. Because the courts don't seem to think that there's anything wrong with you giving gifts so long as your spouse agrees to it, and it's a gift. Mm-hmm. It's not something where you're going to give 80% of your estate to your children and nothing to your spouse. Mm-hmm. Now, this happens a lot. And often it only comes into play after the one spouse dies. And the other spouse finds, gee, there's nothing titled in my name. And he really didn't leave me much of anything in my will. What can I do about it? That's when you go to a lawyer. And he can often get a lot of those things set aside. And sometimes the surviving spouse is concerned. Well, you know, I did sign that. I said, that's okay. Because the law says, even if you signed it, even if you swore on a stack of Bibles that you knew and understood it, that is not enough to continue to allow it to be enforced because it took advantage of you.
Wow. Okay, well, let's move on. Should these agreements be in writing or can they be oral?
Mike, there's something called the statute of frauds, which basically says most of these types of agreements have to be in writing.
Yes.
Sometimes a postmarital or a premarital agreement can be enforced if you can prove it by clear and convincing evidence, and that you would be unconscionably injured or the other person would be unjustly enriched if it wasn't. But those are very, very hard to prove. No, by and large, they've got to be in writing. And what I'm saying to you, though, is even if it is in writing, it will be set aside if it's unfair, unconscionably unfair to one spouse or the other.
Mm-hmm. So I guess there's that old agreement that an oral agreement is as good as the paper that it's written on, something like that.
Actually, a postmarital agreement is not worth much of anything if one spouse gains an advantage over the other.
Okay. So you mentioned pillow talk. What's that?
Well, pillow talk is just a euphemism for the things that I promised to buy you the Hope Diamond if you would sleep with me that night. And the courts used to use that expression to set aside postmarital agreements. In the old days, they said, well, who knows under certain circumstances what you might say. We're not going to enforce those. But generally speaking, they're not going to be enforced anyway if they're unfair. Now, does that mean that if I buy my wife a diamond ring and she doesn't get me a diamond ring for my marriage, that somehow I have to make her give me her diamond ring back? Well, actually, no, the courts don't do that. They don't see that as an unconscionable injury. They don't see that as unconscionably unfair. They see that as the man's generosity. You can make gifts to your spouse.
Well, you mean a diamond ring is one thing. What about the BMW?
She's probably going to be able to keep that one too.
Oh,
now,
darn.
In other words, there's certain advantages and disadvantages to being a man or a woman in the state of California. Most men pay most of the spousal support, although there's a lot of women that are paying it these days because there are many women who are earning quite a bit more money than their spouses, their husbands do. But by and large, things like wedding rings and jewelry and personal property, that's the subject of gifts all the time, and the courts don't usually set those aside.
Okay, my wife gets to keep the rings that we picked up on our vacation. Actually, it was earrings. Okay, well, you mentioned something about family code sections 721B and 1101, which is, of course, Greek to all of us. Maybe you could tell us what that all means.
Those are the statutes that have now taken this common law doctrine of spousal fiduciary duty and codified it. Now it's a matter of a code. And if you breach your spousal fiduciary duty, your wife has the power to sue you for damages, to recover the half of the property that is hers. Actually, during your lifetime, if, let us say, the husband buys a house for his girlfriend, his wife can sue not only to set aside the half of that house that her community property was used to purchase, but both halves of the house. Now, if she finds out about this after her husband dies, she can still sue the girlfriend to get her half of the house back. But these are the code sections that allow her to do that. And they have certain statutes of limitations. Usually you got 3 years to file it from the time you discover it after death. And sometimes you can get twice the value of what it was you recovered because you can prove that your husband was a bit fraudulent in how he did it, which most of the time when he does buy something for his girlfriend, he's not telling you about it.
Yeah. So this idea, well, I guess we're going to talk about that next. So maybe you can go into a little more details about the spousal fiduciary duties, because I think really that's what we're getting into here again.
Again, I could have brought the code section. I'm sorry I didn't.
That's okay.
But it just says that the relationships between husbands and wives are the same as between fiduciary and ward. Mm-hmm. They each owe the other the highest integrity and good faith in their dealing with each other. They can't take advantage one against the other. Let us say that I'm the trustee of a trust for my nephew. You're my nephew. Mm-hmm. And I get to pay myself trustees' fees. Mm-hmm. And I say to my nephew, really it's not fair for you to be getting all this income. I think you should give part of it to me. And you, being not the brightest nephew I've got, say, sure, Uncle Mike, I'll let you keep half the income. And I start keeping half the income. Now, does that mean I get to keep it? No. Mm-hmm. But you said it's okay. I know I said it's okay. But you see, Uncle Mike, you're a trustee. You've got a fiduciary duty not to take advantage of your situation. Well, I didn't take advantage. I asked you and you said fine. That is an advantage. You can't use your position as trustee to gain a benefit. Now, do you get paid reasonable compensation for your services? Absolutely. Mm-hmm. But that's a lot different than you're promising or you're agreeing to let me keep half of the income, or to me to borrow money from the trust and put it into my business at very low interest rates that are not the product of arm's length transactions. That you cannot do, and that you can get sued for. Mm-hmm. Spousal fiduciary duty is the same kind of thing. You can't take advantage of your wife. Now, these words...
Or your husband.
Or your... Well, that's true too, but let's face it, it's the men that are usually taking advantage of the women.
You can tell the kind of cases that Mike has been dealing with. So again, this is his business, regularly cleaning up these messes, and so he knows what he's talking about. It's the men that are getting the advantage most of the time.
They're not getting it, they're taking it.
Or they're taking it.
And there are a number of men that are going to be hearing this program and they're saying, I don't care what he says.
Yeah.
I made this money and I'm going to do what I want to with it. Well, you can try, and you undoubtedly will. Some of us other men might say, you know, that's despicable.
Mm-hmm.
I mean, it's not just that this is a community property state. There are benefits your spouse gives to you, and non-financial benefits you give to her. And the laws of this state basically say it's impossible to measure the value of those things.
Uh-huh.
That's why what you earn, whether you earned it or she earned it, that's community property.
Mm-hmm.
And it should stay community property.
Mm-hmm.
Now, can you change it to separate property? Yes, you can. It's called transmutation.
Yes.
Let us say that you have an agreement after you've been married for a while, and you're looking at your paycheck and you're looking at your wife's paycheck, and you're making 10 times what she's making. And you say, honey, I want you to sign an agreement to transmute. That means change.
Uh-huh.
Your income from your community property into separate property. And I'll do the same for me. What could be fairer than that? Won't hold up. First of all, transmutation's got to be specific and in writing. Well, we did that. But that is the nature of a postmarital agreement. And who got the benefit of it? Well, I did. Because otherwise there would have been $11 million of separate property, not a community property, and she would have gotten half of that. Or I should say, $1 million of community property. And in reality, all she's going to get is $100,000 of her separate property anymore. So that's what's called a breach of spousal fiduciary duty. Can't be done, shouldn't be tried.
Okay. Well, what if my spouse waives my spousal fiduciary duty towards her? Can she do that?
I suppose anything is possible, but if she doesn't have a lawyer, the odds are the same again. It's kind of like saying, it's all right for you to take advantage of me, Uncle Mike.
Uh-huh.
It isn't.
Uh-huh.
It's kind of like saying, don't follow the law that prevents the strong from taking advantage of the weak, if you can get the weak to waive that rights. So generally speaking, I don't think it can be done as a practical matter. The courts are going to figure out a way to prevent it from being done. They're not going to let the strong take advantage of the weak. That's the theory, simply because the weak were too weak to not do anything about it. Now let's remember, we set up trusts because of the fact that often the ward, the beneficiary of the trust, is not as able to handle money as the trustee. That's why it was set up to begin with. So now you're going to let the ward decide whether or not the trustee can take advantage of him or not. Courts don't like that.
Imagine. All right. So now, actually, I was a little worried about how the time is going, because we have maybe about 9 minutes left. But the last question is a loaded one, really. How can our spousal fiduciary duties to each other affect our estate planning? So I think you can probably talk for 10 minutes about that.
Well, actually, this is a really interesting question, because until about a year ago, it couldn't. In other words, sometimes the husband, especially, would try to get the wife to agree to do a will that said the same thing his done. It was called a contract to make a will, but very seldom do they show up anymore. In other words, it's the husband trying to control the wife from the grave. But generally speaking, you can do anything you want to with your community property or your half of it and your separate property. Remember, while you're alive, you can't give the community property away without your spouse's consent. But when you die, you can leave your half of the community property to anyone you want. If I die, I can leave my half of the community property to Cameron Diaz. I could have a wife and 13 children. I can leave my community property all to her. I can leave my separate property all to her. There's not a damn thing that anybody can do about it. That's my right.
Isn't that like statutory share or something? Does that do anything related to that?
No.
Okay.
My wife is entitled to her half of the community property. And if my kids are adults, they're not entitled to anything.
Okay.
So my wife can basically do what she wants to do with her half. I can't do anything about that. But his half, I can give my half to anybody I want. Now, there was a case in the 6th District Court of Appeal that came out about a year ago. And you got to keep this in mind. The 6th District Court of Appeal is the Court of Appeal for our district.
Okay.
And it is the most reversed Court of Appeal in the state of California.
Okay.
The Supreme Court reverses those decisions more than any other court. And it's been going on like that for a few years. And sometimes there's some pretty strange decisions that come out of the Court of Appeal. One was a case in which the husband and wife had both signed the trust, okay? And I think it was I forgot who it was. I think it was the wife believe it or not, in that case, that had gotten the lion's share of the husband's property. You might think, well, that happens all the time.
Sure.
Usually you leave most to your spouse. Yeah. And believe it or not, the Court of Appeal said, well, here's the problem we're having with that. This wasn't just a will that the wife signed alone, or a will that the husband signed alone. This was a trust signed by both of them.
Yeah.
Well, that's usually the case.
Yeah.
When you and your wife go in, you have a trust signed by both of you.
Right.
And then the court figured that, a trust is like a contract, okay?
Yeah.
And a contract's supposed to be fair, right? Entered into between spouses. And this one wasn't, because she got all his separate property and most of his community property, and his kids got very little.
Mm.
So they set it aside.
Wow.
And I thought to myself, holy tomatoes. There are all kinds of these trusts throughout the state of California.
Right.
What does that mean? Every time my wife and I go in to have a trust done, she has to have her own trust and I've got to have mine? Well, how do we fund it? Mm-hmm. How do I put half of my community property in her trust and half in mine?
Yeah.
Can that even be done?
Yeah.
Doesn't she have to sign a document saying you can go ahead and move half of the community property in there? And if she does, isn't that a kind of a contract?
Yeah. Is that a transmutation?
Is that exactly? Well, not a transmutation, but certainly a transfer.
Yeah.
And you'd be right. I think it's a terrible, terrible thing for the Court of Appeal to have said, because I don't think anybody ever intended to change the law that you can leave your money to whomever you want, and that it's a breach of your fiduciary duty not to leave it equally to your kids and her kids, or something along those lines.
Yeah.
But at least that's the language from that one Court of Appeal decision. Now, most lawyers are just, the language is pretty clear about what the Court of Appeal was saying, but I haven't seen any major changes. When you come in to see a lawyer, most lawyers are still doing one trust for both of you. And it pretty much says the first spouse to die, we set up a family trust and a Q-tip trust for that spouse's half, and surviving trust for their spouse's half. And then when the surviving spouse dies, it goes this way. And you can't change the first spouse's half, so what's left for his half goes to his kids. They still are just doing it that way anyway. But
they're all praying that the Supreme Court reverses that decision.
Exactly. Or some other court says, you got to be kidding me, this is ridiculous. Now, in that case, I got to say, there were a lot of other facts that indicated that the wife was taking financial advantage of the husband. Mm-hmm. And they didn't like what she was doing in that respect.
And they say bad facts make bad decisions.
And that's exactly what is partly the truth. Of course, it's also going to be because it was the 6th District Court of Appeal.
My gosh. Well, this is a fascinating area. But, maybe again, I think we've got a couple of minutes left that you can at least throw out some final thoughts from people in this area. But it sounds like, again, that you can't really necessarily rely on these agreements. What should you do? You're getting married.
You're getting married.
And you have substantial
Once you're getting,
assets.
you don't have to be a hopeless romantic such as I am. Of course, that's easy for me to say since I'm not married. But if you're getting married, the two of you are becoming one. Mm-hmm. Okay?
Yeah.
Legally.
Yeah.
And you should accept it in that fashion. If you're concerned about the fact that you make more money than your wife, don't get married. Yeah.
Or if you have substantial assets now, I guess again you come in. That's separate property which you brought to the marriage.
Right. If you have,
so what you need to do then is to isolate those in some way so those can be identified, I guess.
Well, not exactly. It's true that if you have property that's yours when you get married, that stays your separate property.
Yeah.
Now, it's true you might transmute it into community property by putting it into her name.
Yeah.
But again, to do a transmutation by you at your request, it's got to be in writing, and it's got to be specific. Mm-hmm. It's not can't be just an accident.
Yeah.
You can't just title it in tenants in common. It's got to be, I'm changing it from my separate property to our community property. Mm-hmm. However, there are problems when you own things like a house or a business. If I own a house with a mortgage on it and I get married, that house is still my separate property until the next mortgage payment is made. Mm-hmm. Because the next mortgage payment will probably be made with my salary like it always has. But what is my salary now?
community property.
So to the extent there's a principal part of that,
Yeah.
part of that house just became community property.
Uh-huh.
And if after 10 years you get divorced, your spouse is going to get part of that house.
Mm-hmm.
The bigger problem is with his business.
Yeah.
Let's say you own Michael Gray Enterprises,
Well, he might
company that's making a fortune,
Okay.
And it was Michael Gray Enterprises before you got married to Mrs. Gray.
Yeah.
But during the marriage, Michael Gray liked to see his company grow. So he never paid himself much of a salary, paid himself $5 a year.
Mm-hmm.
And then after 10 years, Mrs. Gray got tired of the skinflint and so sued him for divorce.
Uh-huh.
And he said, okay, well, off you go. You take half the bank accounts. He says, no, I want part of that business. And you say, how can you do that? I kept that business in my name alone. And she can. You know why? Because by underpaying yourself for the value of your services to the business, you have basically created a debt to the community.
Oh, boy.
So the courts go and say, okay, part of that business is now community property based upon how much you should have been taking out as a salary.
Wow.
So those types of assets, especially the ones involving businesses, sometimes pension plans, are the subject of premarital agreements,
Yeah.
especially if it's a business, as I said.
Yeah.
So that's the kind of thing you might want to think about going to a lawyer about.
Okay. Well, Mike, we're really out of time. I appreciate you being here with me today again. These are very important subjects that we talked about. They're going to be online, folks, at financialinsiderweekly.com, so you can tell your friends about it. Call Aunt Marge if Uncle Henry's been taking advantage of her. And we'll see you next time
Thanks, Mike.
on Financial Insider Weekly.